Hello, good evening, Tonya. Or Tonye, sorry. Good evening. Can you hear me?
Good evening, Mr. Dennis. Yes, I can hear you.
All right, thank you for joining in early on. So we don't yet have anyone else on the call besides both of us. I'm logged in on two other devices, but we'll be carrying on irrespective. So moving on, I'll just quickly be taking announcements, and because we don't have the mentors yet here on call, I'll be reading their profiles, and then hopefully they'll be joining us soon. Right. Thank you, Chioma, for joining. You're welcome to today's class. All right. So good evening, everyone. My name is Dennis Williams, and I will be your moderator for this particular class. Welcome to week 4 of the patents drafting class. So far, we have gone through week 1, week 2, week 3, week 4, and we're almost at the end, or we've gone so far in the program so far. So I think in the coming week we just have one class left for the patent drafting class as a whole, and then the subsequent classes are going to be combined class. So the subsequent classes are going to be combined classes. So I truly hope that what the mentors have been sharing in subsequent classes, that is in from week 1 to week 3, has been beneficial to has been very beneficial to us, and we have gotten or learned quite a lot from everything that they've had to share. Right, we are almost getting to the crux of the program. So I still ask, or I employ, for those who are on the call, to take maximum advantage of what we have been offering in this particular program. You can always revisit the classes that we have gone through on our YouTube page. You can just type at JIIPCC. The links are also posted in your group, so in the main group, so you can always look at that, and you can revisit when you need to refresh your knowledge. So moving on into today's class, thank you so much, Ms. Shukurat, for joining us. We're happy to have you here with us in class. So moving on, like I announced in the last class, we are still on the free legal clinic for creatives, entertainers, athletes, innovators, and startups. So please, if you kindly know anyone, right, or you kindly know anyone, or you have friends or colleagues, or even you yourself, who is in need of a 20 minutes consultation and wants contracts reviewed, you can kindly reach out to me. That is the registration slot there. But you can also reach out to me to help share the flyer if you want to also be involved in the publicity of this particular program. So this initiative is brought to you by Gypsy Academy, right? And we hope to give back as much as possible to those who may not necessarily be able to afford legal advice in that sense. Um, Moving on to our mentors, Mr. Rakesh is not yet here with us. But Mr. Rakesh, I think he has been here with us in one particular class. Being that the time frame or the time difference, right, within where he is and the current time zones we're using is not necessarily the most convenient for him. But I hope and I trust that he would be joining us into this class. So, Mr. Rakesh, okay, not to bore you with the reading of the profile, right? Since we've done that in, I think, 2 or 3 classes already. So moving on to our next mentor is our ever available, our lovely mentor, Miss Amusa Shukurat Modupeola. She has been with us from week 1 down to this very class, and we are always happy to have her with us. She always wants to break down everything and revisit and just draw back our attentions to things that have been always said, that have been earlier said, highlighting particular points and then also answering questions. So we thank you very much, Ma, for the time and effort you have given to this program and to this particular class. We do not take it for granted. We really, really do appreciate your presence here with us. So our topic for today is claim design and drafting. Our topic for today, once again, is claim design and drafting. And I hope that, we are able to get a lot of insights from our mentors, and that the research we have put together will be able to present it in such a way that every other participant, or everyone, will be able to also benefit from the presentation we'll be making in class. So welcome once again to week 4 of our third and fourth quarter 2024. Without further ado, we'll be handing over the floor to Miss Shukurat. If she has any presentation she would like to share with us, please, ma, the floor is yours for that, ma.
Hi, Dennis. Good evening. How are you doing?
We're very fine, ma. Thank you so much, for joining us.
You're welcome. So we are not sure if Rakesh will be joining, right? Can you
Sorry,
hear
not
me?
exactly. Yes, not exactly. He confirmed, but we are still expecting him.
Okay. I think we should allow the presenters to present, and just to buy time in case he probably might join.
All right, thank you very much, ma. So I will stop sharing my screen right about now, and then please, like Miss Shukrat has earlier said, please let's get to presentations first, and then let's get to presentations, and then we'll hear comments from Ms. Shukrat. And if Mr. Rakesh joins in, we hope he can also deliver a presentation in that slides. So please, over to the mentees. The floor is yours for your presentation.
Good evening, everyone.
Yes, good evening, Mr. Blessed.
Good evening, everyone.
Yes, good evening, Mr.
Good evening.
Blessed. We can hear you.
Thank you. Yeah, thank you very much. I'm from Group 1, and today we'll be talking on clean design and Sorry, Dennis. I don't know if you could help me with my screen. I'm not sure I can share it from this end.
All right, so please give me a moment. I would do that right now.
All right, thank you.
All right, so please, you can carry on with the introduction. The slides are coming up soon, right now. So can you see my screen?
Mr. Dennis, this is for group 2.
It was
So
only
do we
one
have two
present.
groups? Yes, I only
It's
got
only
your presentation as well.
Yeah, it's only one group we have for the patents drafting class.
Okay, sorry, my mistake.
All right. So Mr. Bless, are you with us? Okay. I can see you on the call. Can you hear me? Mr. Blessed, can you hear me? Okay. I think he is having a little network issue. Please, can we have someone else from the group start with the presentation while we wait for him to rejoin?
Good evening, everyone. Tony, I will take over the presentation till Mr. Blessed can join again.
Okay, I can hear you now. Sorry. Please,
Or
can you please take to this next slide, please, the introductory aspects.
all right.
All
So
right.
please, you can carry on with the presentation.
All right. Now, as I was saying, the whole issue of IP, the whole issue of patent all stems from IP, and patent protection actually has to do with the most the technological aspects of IP. So in drafting a patent, one thing is very crucial, which is understanding both the invention and the legal landscape. When we talk about understanding the invention now, inventions varies. Take for example now, a rectangular table now has four stands four stands, while a circular dining table has three stands. Those two tables differ. And when we also talk about the legal landscape, we're talking about the jurisdiction. The laws that apply to drafting a patent in Nigeria will definitely differ from the one in SA, India, or Europe. So going further, an effective clean design ensures that an invention is adequately protected against any form of infringement, while also resilient to challenges from the prior art. This now leads us to our first topic, which is claim construction. So now, what is claim construction? It's actually the process of protecting the scope and the meaning of the terms used in a patent claim. When we talk of scope, we're talking about the broadness of the patent claim. In the prior classes, we were made to know that when drafting our patent claim, it is meant to be as broad as possible, as it's meant to be all-encompassing as possible. At the same time, it is still yet meant to be very specific to initiate the key terms, as I initially referred to the issue of a rectangular table and a circular dining table. There again, when these are, and also down to the terms now, the terms are very crucial because for those of us that practice law in a full service litigation law firm, we are made to understand that or rather when you are drafting probably a land agreement, we are made to understand a wrong word is very likely to alter the entire course of the entire agreement. So when we specify this specification of all these things is very fundamental when drafting claims. And when all these are done, it helps in determining the extent of the full term protection. 2, dispute resolution in the sense that laws that apply to dispute resolution, to the best of my knowledge, in the English and Welsh jurisdiction, what is required in their jurisdiction there is every form of dispute that may arise when drafting a patent should be referred straight to arbitration. That's to the best of my knowledge. And next, also help us understand the invention. It helps us to understand the inventor as what the inventor has actually invented, to know if someone else work fall within the scope of the patent. This is very fundamental in the sense that if his work falls within someone else's work, the patent may actually be rejected. And even if it was granted, it can be subsequently rejected. So next, we'll talk briefly about our prior art analysis. What does prior art analysis? It involves reviewing existing patents, publications, and other public disclosures in construct with the patent that we intend making an application for. And the purpose for doing all of this is to evaluate the novelty and non-obviousness of the patent application we are making. Because if our patent application doesn't beat the novelty test, there's every tendency it can be rejected. And also this can be done by simply carrying out searching existing patents and non-patent literature by using search techniques such as keywords, classifications, or critical analysis. In the prior classes, we've been made to know that when we are searching for, and it said an invention that falls in line, we don't just go and type the title of the invention. Take for example now, if we're inventing something like a big barrel, you won't just go and type a big barrel. No, what you actually do is to type a keyword in line with that invention to know if there has been something similar to that prior to now. Now, what are the benefits of prior art analysis? Please, next slide. Number one, it helps to verify the originality and the quality of the inventions brought by the patentees in patent application. Two, it established the novelty and the inventive step of the invention. Three, it also helps to prevent duplication of existing knowledge and ensures that the invention meets the criteria for patentability. It helps to prevent duplication of existing knowledge, because the whole issue of registering a patent has to do with something that is new, something that is fresh, something that's probably to a large extent, not totally, has never been seen before. It's also noteworthy to note, as I've earlier stated, that if it fails to beat this prior art test, there's every likelihood the patent will become invalid and subsequently rejected, even though it has actually been said. And also, when filing for our patent application, we're not just to focus on the geographical jurisdiction. Take, for example, now, if I'm registering a patent within the Nigeria jurisdiction, I will just focus the prior art analysis within Nigerian jurisdiction. No, I'm to go further into other jurisdictions, and this will actually serve such a Nigeria. So please help me with the next slide. Thank you. So now we'll go into the parts of the claim. A patent claim is a state one, which is, we basically have three parts of a patent claim, which is the preamble, the transition phase, and the body of claim. The preamble is majorly the introductory part of a claim. It's the introductory part of a claim, while the transition phase actually is a phase that actually links the preamble to the body of the claim, and the body of the claim is divided into three: the elements, the steps, and the relations. The elements now are the specific components or the features of the invention. The steps, these are the sequence of actions or operations in a method or claim. The relations are actually how the elements or steps interact or are combined. Next, please. So to draft an effective claim, the following strategies will be considered, which is number one, to balance the broadness and specificity. I've actually spoken about this probably during the introductory aspects, because despite we are aiming for our patent protection to be as broad as possible, as we've been taught in the prior classes, we are yet to be very specific as much as possible. Two, we are to use precise and clear language. This is not just research to patent. This is what we'll be learning throughout the university. Words that don't portray any form of ambiguity. Theory, we are to provide adequate support, focus on the novel aspects, because we've also been taught that a patent necessarily must not be 100% novel. Tell what to consider multiple embodiments, anticipate challenges, align claims with business objectives, maintain consistency, in the sense that a word that we use when drafting the patent claim should be what we constantly use throughout the whole drafting of the patent claim. We're also to utilize proper claim structure. And lastly, we're to review and refine. Is the last slide, please. So in conclusion, the key three parts of these whole subjects are the claim construction, the prior art analysis, and the adherence to the best drafting practices. And once we do that, then the claim is good to go. Thank you very much.
Thank you, Blazel, for the detailed presentation. That was actually a very good presentation. However, it would have been nice if we have diagrams to show how you use these words. Say, for example, you have example of probably a kettle, a method of producing this and that, or probably an equipment, and show us how the body, the transition, and the preamble, how they connect, and also showing how the claims you're talking about, how does your invention, how can your invention be infringed if it's not included in the claim? But altogether, that was a very good presentation. I'm actually trying to join with my system, so I can't share my slide. I don't know what's wrong. Maybe it's network.
All right, I think mine is from your, probably maybe from network issues. And thank you so much, Blessed, for that wonderful presentation. So we haven't gotten any news from Mr. Rakesh, and I think he may not necessarily be, I don't think he'll be able to join us in today's class.
I think I'm in now, so I'm just going to share my slide so I can talk about a few things.
All right, thank you very much, Ma.
Kindly confirm when you see my screen.
All right, it's not yet up.
Yeah. So I'm going to be sharing 2 slides. I'm going to start with the first one. Let me see. Just give me a few minutes. Let's see. Can you see my screen now?
Yes, it's coming up. It's up.
Okay, so I think we
Yes,
already
you can.
discussed this in the previous class. So I'm going to start from okay, so I'm going to start from structure of patent application. Okay. So what should your patent application look like? How should you structure your patent application? So from what we have here, structuring your patent application, you want to look at the title of the invention, your abstract, your technical field, then the description. Now, the description talks about the background of the invention, summary, brief description, drawings, and we have the last one is claims. So doing this, the title of the invention is what we say, this is what the title is. A process of making a ballpoint pen, this and that, that's the title. The abstract just gives like an overview of what the patent application is talking about. Then the technical field is talking about what field does this invention relate to? Is it the medical field? Is it the human necessities? Is it physics? Is it chemistry? Because while you are doing a patent search, the technical field also helps you while searching using an IPC or a CPC system. I don't know if you've come across that. We have the IPC system, that's the International Patent Classification. Just like we have trademark classification in trademark, we also have classifications for other aspects of IP, such as patents. We have the IPC, that's the International Patent Classification, and we have CPC. CPC is mostly used by the USPTO and the EUIPO, and that's the EPU. But the IPC is like the international one, which is majorly used by WIPO. So if you see some patent applications, let me try and share. I think I should have one. Okay. I should have one. Let me see if I can share what a typical patent application, a granted patent look like. So we can talk about the structure of the application. So let me just check briefly so I can share with you. I think I have something. Just give me a few minutes, please. Okay, I think I don't have it, but this is what I'm going to do. I'm going to share my slide. So let's quickly carry out a search together. So I also show you how to carry out patent search. So let me open my browser. I have a particular, I want us to search. Just give me a few seconds. Let me get. Okay, I'm going to stop this and reshare. So just confirm when you can see it. Can you see my screen?
Yes, it's up.
Okay. It's on Google, right?
Yes, it is.
Okay, so let's carry out a search together briefly. You can either use Google Chrome. We have different search engines or search patent database for patent search. We have Google Chrome, sorry, we have Google Patents, we have Patent Scope, we have USPTO, GPO, sorry, JPO, Lens, Patent Scope, and so on and so forth. So for this search, you'll be using Patent Scope. So Patent Scope is more like the WIPO patent database. So here you're going to type patent scope. You can see I already have something here, patent scope. It's going to take you to WIPO database. So you click patent scope here. Then you go to access patent scope. So this is what the WIPO patent scope database looks like. So I know from Blessed presentation, it mentions something about search terms and so on and so forth. So this is where you want to put in your search term. Now, if you go up here on where you have search with this arrow, if you click on the icon to give you a drop down, you can either do a simple search, an advanced search, or a field combination. So this simple search is just looking for maybe your search word is maybe kettle. You can just type in kettle. If you want to do an advanced search such that you want to put in the title, a bit of the abstract, maybe the inventor name, you use advanced search because it's going to give you so many things. Also, you can also use field combination. You want to combine this field with that field. So this is what it looks like. If you want to use operator, we have and operator, we have or, and so on and so forth. This is too technical anyway. Let's just go back to what we came here to do. So I have a publication number I want to search for. So I'm just going to paste it here. And this is it. Whenever you see WO, means it's an international patent. That's WO. So you search for it and it gives us this. I think it's a what's the title again? Okay, so it's a biodegradable tennis ball. That's this title of this application. So from what we can see, you can see the title, just like I was showing us earlier, the structure of a patent application, the title. The title is biodegradable tennis ball. And from here, you can see the publication number. That's after it has been published. You can see the publication date when it was published. The international patent application number, like I said, WO is an international patent. And for you to file an international patent, you have to go via the PCT route. Then the international filing date is this. This is the IPC I was talking about. If you want to use your IPC to do your classification, we have IPC, we have CPC. So under this IPC, you see, okay, that's good. Can you see this arrow? It's showing you that A is human necessities. So we're talking about technical field. That's why I came here. Like I said, we have different classifications, just like we have for patents as well. So this particular one is for the IPC. Kindly give me a few minutes. Okay, so sorry for the breaking transmission. So what we have here now, if you look at IPC A falls under human necessities. So we have the classification A to H, G8, I think H, yes, if I'm not mistaken. So under human necessities is the section. So we have section, we have subsection, we have class, just like we have all these classifications. So under human necessities, this particular title, it's under sports, games, and amusement. Now, under sports, game, and amusement, there's another section that has to do with apparatus for this and that. In your free time, you can just browse through IPC. It will take you to the IPC classification, and you will see all these classifications. Like I said, the same with CPC, but CPC is majorly used by the USPTO and the EPO. Now, who are the applicants? See the applicants here. We have 3 applicants. 1, 2, 3. Who are the inventors? You see that from what we have here. The inventors is the same people as the applicants. So in this case, our statutory inventor is the same as the true inventors. So we have the same people here. However, in some cases, the applicant might not be the inventor. In a case whereby the applicant is not the inventor, it means the applicant is just the statutory inventor, while the people who are the inventors are the true inventor. So who is the agent? Is this Muta or Mutanatan that helped them to file this application? Are they claiming priority dates? You can see everything here. Publication language, English, filing language, the designated states. If you check the designated states, you see how many countries also that was designated, because this is an international application. And for international application, you can designate as many countries as possible. So these are the designated countries. Can you see how much they have? So they designated ARIPO, this is ARIPO, designated European Patent Office, that's the EPO, designated OAPI, African International Party Organization. They even designated this Eurasian Patent Organization and every other ones that are here. So all of these countries, it means this patent is protected in all of these countries. However, if you look at the priority dates, you see that it's showing US. That means this application was firstly filed in the US on the 16th of, is it May? January, February, March, April, May. Yes, on the 16th of May, they filed this application. Oh, sorry. On this 18th of May, this application was filed in 2022, 18th of May. Then they claimed priority on the 16th of May, 2023. I don't know if you've read up on priority. But what priority does for you is that countries who are member states who are contracting parties of the Paris Convention, there's something called priority date, such that if you file an application in a particular country, you can claim priority within 12 months. So if you look at these priority dates, you see that from 18th May 2022 to 16th May 2023 is not up to, like, it's not exactly 12 months, right? There are some days. Assuming they filed on the 18th of May, this application might not be able to claim priority again. So you see they filed on the 16th, just to be on the safe side. That means any application that is submitted on this same topic within this period is not going to nullify this application, because they are going to claim this priority date. So that's what priority date is all about. Now let's look at what the document itself look like. So this is the description of the invention. And then we have the claims. So this is what is claimed. Can you see what is claimed? A biodegradable tennis ball. And this claim is what is the title. When we check the title earlier, you see that it is a biodegradable tennis ball. So what your title is in that same line, your claim will go. You will name your title a biodegradable tennis ball, and your claim will now be saying a method of producing. It won't go that way. So it has to go the same way. Now, this a biodegradable tennis ball, it is what we call the preamble. Now, you see the next thing that follows is comprising. So I noticed in your presentation, you talked about comprising, consisting of, and one other thing. Now, depending on jurisdiction, most jurisdictions prefer you to use comprising, because normally the normal English should be consisting of. But consisting of is kind of like a closed-ended claim. So you want to use an open-ended claim that gives you that grace, such that when you say comprising, it means it comprises of this, and it could even include other things that wasn't mentioned. But when you say consisting means consisting of just what you have mentioned. If it's not here, then it's not here. So you want to give yourself that grace, and as such, it's mostly recommended to use comprising, though there are some jurisdictions that still allow you to use consisting, but you have to be very vigilant of what you are doing and which jurisdiction you are filing in. So we've talked about the we've talked about the preamble, the transitioning phrase, which is comprising, and now the body. The body is where we have a core forming a hollow interior chamber. The core comprising a first blend of rubber-based material, a first petroleum-based material, and a first biodegradable additive, and a second layer, blah, blah, blah. Now, you see this first one, you will see that one way or the other, it tries to link everything together. And that first one is what we call the independent claim. The independent claim is always standing on its own. However, and following, you now see some dependent claim, which is going to depend on the independent claim. So if you look at the first one, it says a biodegradable tennis ball. And whenever you are drafting your first claim, which is your independent claim, you always use A, not D. So the independent claim will always carry a method of producing a biodegradable ball, a kettle, a this or a this or that, but it's always A. But you see the following ones, which are the dependent claim, will have to change to D and not A. So you have to look at that. Now you see that the claim 2, it says the biodegradable tennis ball of claim 1. Or you say the biodegradable tennis ball in claim 1, wherein, so this dependent claim, it now it narrows down. The first claim is always broad. It won't give you so much details about it. But you see the following claims, which are a dependent claim, will now narrow everything down. If you look at claim 7, so if you look at claim 8, it says the biodegradable, claim 6, sorry. The biodegradable tennis ball of claim 1, wherein the first petroleum-based material comprises one of nylon, polyester, or polyethylene. But if you look at the independent claim, you see it just said comprising a first blend of rubber-based material, a first petroleum-based material, but they didn't go ahead to give us hints on what the petroleum-based material is in the independent claim. But you will find that in your dependent claim. So when you are drafting an independent claim, don't say maybe a material for writing, comprising a red cap, a blue ink, a this and that. No, your independent claim should be very broad and still straightforward. You shouldn't have this kind of ambiguity. But your dependent claim will now talk about these things one after the other. Now, if you follow me and you look at claim 11, you see that the claim has changed because this patent is a product by process claim. That is, it has both the process and the method. So this invention is like a two-in-one. It's talking about the product, which is the biodegradable tennis ball, and the method of manufacturing the biodegradable tennis ball. So instead of actually drafting two different applications, you can have a two-in-one patent, which is a product by process kind of claim. So looking at claim 11, it says a method of producing a tennis ball comprising, it now lists everything. Then in the following claims, you now see that claim 12 changed to D, but you see that claim 11 still maintains A. So all your independent claim, like I said, has to start with a preamble, a transition, and a body. And it will start with A, not D. But the dependent claim will always start with D. You realize that in claim 12, they said the method of claim 11, not the method of claim 1, because the method claim, the independent claim for the method claim is starting with claim 11. However, the one for independent claim 1, you see that from claim 2 to claim 10, they are referring you back to what? Claim 1. The biodegradable tennis ball of claim 1, because that is the independent claim. So all of these other claims are depending on claim 1. That's why they are dependent claim. And claim 1 is standing on its own, and the reason why it is an independent claim. So this is just to show you how claims can be. And this is what the drawing looks like. So you can see we have two different drawings here. The first drawing is for the products drawing, and the second is for the process. So when you're talking about process or method, it's more like a list, step-by-step process. And that is why it's like this. But you see the one for the product, it just gives you the diagram of maybe point 1, point 2, point 3, point 4, and so on and so forth. And when they're talking about this in the detailed description, they will link it to all these number. How does this number 1 connect to number 2? So that's how it always is. So I think that's it. You don't need all of this. You don't need all of this. So that's that for that. So I'm going to stop sharing this particular slide. Then we can continue from where we stopped earlier. Okay, so we're talking about the structure, actually. Sorry. Okay, so let me know when you can see my screen. Is it up now?
Yes, it is more.
Okay,
Yes, it
so
is.
we talked about the structure already. I won't be talking much about it because it's just to tell you what the structure looks like. Then let's come to practical aspect. So the claim are the act of any granted patent, just like you've said, and thus it defines clearly the scope of the exclusive rights. I know you were talking about chair this, chair that, but because there was no diagram, we couldn't really see what you were talking about. So I'm going to explain better here. So you can see what we have here. This chair over here is the prior act. And looking at this chair has 4 legs, it has a backrest, and it has a seat. So if you want to write an independent claim for this, it could be a sitting material, or you don't say a chair because anything could be a sitting material. You can say a method for sitting if it's a process, or let's just say a sitting material comprising at least, let's say at least 4 legs, a backrest, a seat, and that. Now look at this invention X. This invention X also has how many legs? It has 4 legs. In this case now, it has a seat. It has backrest. Now it has armrest. And it's like a rocking chair. It has like this rocking chair under. If this invention X only claims a seat, backrest, and 4 legs, then this Power Act is going to invalidate it because this invention has everything claimed in the Power Act. But if this person claims maybe a material for sitting comprising a rocking, something, armrest, backrest, seat, and this, then you see that this Power Act doesn't have some of the essential elements as listed by this, right? So look at invention Y now. Invention Y also have kind of a rocking chair. It has a seat and it has backrest, but it doesn't have armrest. So all of these things are things to put into consideration whenever you are trying to like draft your claim so that you don't shoot yourself in the leg. I've already explained this earlier, so I won't be talking much. Preamble, transitioning phrase, and body. So we have comprising, consisting of, consisting essentially of, but like I said, comprising is what most jurisdiction uses. However, there are some jurisdictions that still allow you to use consisting of. Do I have any other example? Okay, something like this. A jet engine comprising a composition. So this a jet engine is a product claim. A composition is more like a Makush claim or a chemical compound claim. Then a method of making tea is more like a process claim. So look at the preamble, a jet comprising, look at the body, an air inlet, an air outlet, a compressor, a combustion chamber, and a turbine. And look at the same thing. Now look at this one, a method of making tea comprising the steps of, so you put that steps in a broad sense. Now the dependent claim will now talk better on the steps of boiling the water. Are you boiling it at what degree Celsius are you boiling it? Does it have to turn brown before you drop it? At what point do you drop the leaf? Is it when the butter is boiling and the steam is coming out? So all of these things will be listed in the dependent claim, but not in the independent claim. So filing your patent application, we have 3 filing strategies. We talked about priority date when I was talking about the example for the invention earlier. Now we have provisional application. Provisional is kind of similar to priority, but it's not priority. In the case of provisional, you are not really claiming the priority date. Provisional is just like, okay, fine, I have an invention I'm working on, although I'm not yet done with the claim and all, but I want to file this thing so that somebody else doesn't go ahead to file. So provisional, you file. Then when you file, you don't have to submit your claim and all. So within the next 12 months, you have to file your non-provisional application, which is your main patent that now has all your claims, your drawing, and all of that. Priority date is you filed earlier in one jurisdiction, you want to file in another jurisdiction, and you want to claim that same priority date of your first filing date. Grace period is probably when you exhibit or you showcase or you disclose your invention before filing your application. In this case, there are some jurisdictions that give you a grace period. I think for the grace period for Nigeria is 6 months. Is it 6 months or 12 months? I really can't remember. But some countries give you the opportunity of 12-month grace period. I think it's 12 months for patent and 6 months for trademark. I really can't remember, but something like that. But grace period is just that, okay, fine. You've showcased this thing before filing. You have this grace period of so amount of months to file, and that disclosure is not going to invalidate your application. So what routes can you file? We have the national route, we have the regional route, and we have the international route. National route is when you file in the country, like each individual country. Regional route is when you file in a country whereby there are different other countries, such like the ARIPO, the OAP, the EUIPO, and so on and so forth. And PCT is when you file internationally via WIPO. That's PCT. So this is what the PCT looks like. We'll talk about this on the day we are talking about registration. Then basically, this is not part of it. So that's just it. That's it, actually. So if you have other questions, I would like to take questions at this point. Thank you for listening.
Thank you so much, Ms. Shukurat, for sharing all that. We really, really appreciate. Thank you, Blessed, for the emoji. All right. Please, can we have other mentees just react to the session? I'm sure it has been insightful so far, and Ms. Shukurat has done so well in breaking that down with even examples that she shared from our own end. So thank you so much, Ma. We really do appreciate. So please, we are taking questions. Do we have questions from the mentees?
Good evening, Ma.
Good evening.
Thank you so much for this teaching this evening. Okay, so I have a question.
All right.
If my client has several devices that he registered individually in Nigeria, but now he wants to register, patent it abroad, and he's asking for the patent to be 1 instead of 3 and submerge the other 2 into versions. How will I go about that, please? Let me give
Has
you
he
the
already
difference.
applied? He has already
Not
applied?
yet. In Nigeria, we've applied and
Okay.
I've gotten the certificate for 1.
Okay.
So the devices, one has, the difference between the 3 is one has current transformer that is, the measurement is 12 kilowatts, while the second one is 11/33 kilowatts, while the third one is a flow meter.
But it's just a product, right?
Yes, it's a product.
The best thing is to apply differently. If you look at the example we gave now, is a product by process. You can't have product by product patent. Okay?
Okay.
So it's actually a product by process or process by product or method by product. You can't have
Okay.
product because as it does it now, it's able to exploit each one individually. Okay? If you have
Yes,
everything into one, it means you are going to be giving your licensee the rights to exploit more than they should. But when you have them separated, they can license one to each person that wants to use it.
his complaint of registering it in the US as 1 is because of the fee.
It's
That's
better
why.
for him to have those 3. So what it's going to do is it will be like a family patent or like a patent of addition. Okay? So when he
Okay.
files 1, the next one will come like an additional part of what he has done. And while
Okay.
filing, he can always claim priority so that when you are checking it, you will see that he has done 1 that still relates to this, just that the meters or the numbers are just different.
Okay, ma. Thank you, ma.
You're welcome.
All right, thank you. Thank you, Tonya, for that question. Please, do we still have any other question from the mentees? Do we still have any other question? Anybody with a question they would like to ask in specifics to this class and maybe based off the research? Okay, Mr.
Good evening,
Blessed,
everyone. Good evening.
Good evening.
Good evening. You're not so audible. Can you speak up a bit?
Good evening, everyone. Good evening, Ma.
Good evening.
Tonya made mention of she said our client was complaining about the fees. Well, to the best of my knowledge, even when you are registering probably with the CAC, you are meant to pay an application fee. I'm just out of curiosity, like these fees, like what's the range exactly, Ma?
You can't compare Nigerian filing rate to the US because
Yes.
with US is more work because they do substantive examination. We don't do substantive examination in Nigeria. Okay, so they do substantive. So the workload is much. And you can't say this is the range because each person charges depending on the technicality of your work, their experience, and how versatile they are in the field. So I really can't say this is the range. There's no range, actually. There's no range.
You noted and appreciate.
All right, thank you, Blessed, for your question. Do we have any other person with a question?
Okay, yes, I actually have one question. Good evening.
Good evening.
Good evening, everyone. Good evening, ma.
Good evening. I can hear you.
Thank you very much for the class, ma. When I was doing a research for my article, there was, I think, about 2 articles where only one where they said that patents are generally divided, that the patent claim can be divided into just 2 main parts. The patent application can be divided into main parts, which is the claims and the specification. He just lumped the whole. Now I'm talking about from the academic standpoint. Now, when writing an article, is it right to say that is how patent is divided?
It depends on the understanding. So majorly, specification is majorly used by the international people. So in most cases, it depends on how you want to classify it. As long as you mention your claim, you mention if you say specification, most of the specification or most of the summary, detailed description, they fall under specification. So because sometimes when you say specification, people might not understand what specification is. So if you want people to understand better, it's better for you to just list them out so people can understand that, okay, fine, this is what is included under the specification.
Okay, thank you very much, ma'am.
You're welcome.
All right, thank you.
Ma,
Thank you very much. Okay, please go
Okay.
ahead.
Sorry, I have one more question.
Okay.
Ma, when filing under PCT, that's via WIPO, do you
Yeah.
get to specify the countries you want your patent to be applicable in?
Yes, you designate the countries you want to be you want your patent to be filed in.
Okay. Thank you.
So when you designate at the end of the phase, which is national phase, when it gets to the national phase, then each one goes to each countries you've designated. Now it's now left for that country to decide to grant or not to grant, depending on the laws of their jurisdiction, and if what you've written is up to standard in their own jurisdiction.
Okay, ma. Thank you, ma.
You're welcome.
All right, thank you. Thank you to all the participants for their questions. To the participants that asked questions, thank you so much. And thank you to Ms. Shuparat for helping us answer our questions. So I think it's safe for us to say we've had quite an interactive session, and Ms. Shuparat has helped us just do due justice to today's topic. So in light of that, we'll be calling it a nice to class, but just before we go, right, just as we always do, we like to take a quick picture for those who have a little lighting in their background. Please, you can kindly turn on your videos so that we can take a quick screenshots for posterity and also for our social media postings. Thank you, Mr. Blessed. So do we have any other person on call with a little lighting in their background? All right, can we have someone else turn on their video if that's possible? Thank you. Okay, that's fine. That's fine. I've been able to take one, and I think that's just okay. So in the absence of anything, right? Good night, everyone. Thank you so much for joining. Thank you to our mentor, Ms. Shuparat. Okay, I can see she's no longer here. Okay, since she's no longer here, I would just like to encourage the mentees. In the subsequent class, please, I would like to encourage all of us to work together and always ensure that as much as we can, let us try and make our time to always be available for sessions. you can schedule and you can plan yourself very well to ensure that you are always available. It's 6:30 in the evenings on Sundays, so you can always make room for that while you plan for your day. So like I said earlier in the class, I said that for the patents class, we have just one more class to go for the patents class, and that will be next week, right? So the research that will be sent to you, like I said, is let's put in the efforts to ensure that we have a good last week presentation for patents, and then subsequently in other sessions, that is the combined sessions, instruction as to what is expected of you, right, will be communicated to the group. So thank you as you comply. Good night, everyone, and enjoy the rest of your evening.
Good night.
Yes, good night. Take care.
Good night.